weed. I got 5 on it. It's got me stuck and I go back. I got 5 on it. Partner, let's go half on a snack. I got 5.
Smoke a little something for the beast.
I got 5 on it. I got 5 on it. Yeah, I got 5. I got 5 on it.
Smoke a little something for the beast.
I got. Grab your toy, let's get keyed. I got. Messing with that in the weed. I got. It's got me stuck and I go back. Got. Partner, let's go half on a stack. I got 5. I got 5. Messing with that in the weed. I got 5. I got 5 on it.
Smoke a little something for the beast.
Messing with that in the weed. I got 5.
Smoke a little something for the beast.
Oh, we're waiting on the judge, man. He's supposed to be here already. Was he at? I don't know. He's like, maybe has an issue, a gastrointestinal issue or something. He was supposed to be here at 4 Florida time. Yeah. LP Live 1X. What, dude? What are you acting so for? Doing a live stream your court. I don't know if it works like that. Are they going to be? Is it going to be on YouTube? I follow you, and I'd appreciate if you follow me back. Guy's strong arming me over here. I mean, don't you want people to follow you that actually want to watch your content? And not just people that follow you just to follow you? Because that shit ain't gonna ever work. I don't get it. Like, he doesn't even tell me, like, what he does on his on his stream. He's like, hey, just follow me. I followed you, now you follow me. What? No. You can unfollow now, it's okay. I'll be okay with it. I'm sorry to see you go, man. What are you doing? Eating me? You eating me? Get out of here! What are you doing biting on me so much? Hey, welcome back, Sis T. Oh, see, now you're gonna go piss Simon off. Get her, Simon. He's bopping her. You wouldn't woke him up. Bop her in the top of the head. Bop her. I think he appreciates her, though, even when she wakes him up. I mean, I can only imagine being the only human and cats being in charge of me. And then all of a sudden there's another human there. Yeah, we might not get along all the time, but I definitely wouldn't want the other human to leave all of a sudden and stick me with the cats again. Right? I mean, unless all of a sudden it made my life less opulent because like he was the king. Now he's not so much the king. And maybe that bothers him. He stares a lot more than he used to. I feel like in some ways this is keeping him young because he's running around and playing. But in others, it's aging him because he sees that he's no longer young. He didn't used to see another cat be able to jump so much higher than him and be so much more athletic. Now he realizes his age more. I mean, I think I see it in his eyes. Look at these folks so long. Go with that. That is not. Boy. She's biting this. I still haven't even sprayed her with it yet. She just knows.
Fortunately, we...
No! What happened? I was just saying unfortunately for her. Are we good?
All right, let the record reflect that State's President, Defense Counsel, and the defendant are all present. We're here for sentencing. Was there anything else that the court needed to address prior to sentencing?
No. No, God.
All right. So I have considered all of the testimony and evidence, arguments of counsel, applicable case law, and statutes. I have prepared a written sentencing order, which I will file contemporaneously with the pronouncement of the sentence here today. I also have copies for the state and defense, which I'll hand out once I conclude. So in the state of Florida versus Wade Stephen Wilson, case number 19 CF 568, the court will read aloud the portion of the sentencing order related to the sentencing circumstances and proportionality. In evaluating the aggravating and mitigating factors, the court does not engage in a mere counting procedure, but instead makes a reasoned judgment based on the totality of the circumstances. In reaching this decision, the court is mindful that because death is a unique punishment in its finality, its application is reserved only for those cases where the most aggravating and least mitigating circumstances exist. The law never requires the imposition of a death sentence. In this case, the totality of the circumstances indicates the defendant, with premeditation, beat and strangled Kristine Melton in her home before stealing her vehicle and driving to meet his girlfriend, Melissa Montanez. After Montanez refused to get into the car with him, the defendant battered her in broad daylight. The defendant told law enforcement, when Ms. Montanez managed to flee from the defendant, he fled the scene and drove back to Cape Coral, where he decided that he would murder another person. He saw Diane Ruiz walking to work and pulled over, pretending to ask for directions. She got into the car to provide directions, but the defendant strangled her when she tried to exit. He then drove to an empty lot, strangling her into unconsciousness at least one additional time on the way there. When she tried to flee from the car, he drove over her at least one time, inflicting mortal injuries to her spine, ribs, and neck. The evidence showed that both murders were heinous, atrocious, and cruel, and that the second murder was cold, calculated, and premeditated.
I bet he gets death.
The defendant inflicted serious physical and emotional pain to the victims. Moreover, the defendant committed the murders while on probation for prior felony convictions, and he committed 2 first-degree murders contemporaneously with each other and with grand theft of a motor vehicle, battery, and burglary of a dwelling. There were no statutory mitigating circumstances that were established, but the court considered the non-statutory mitigating circumstances presented by the defendant. Out of 13 enumerated non-statutory mitigating factors, the court found that 10 had been established. Out of those established, 6 were given little weight. The totality of the mitigating circumstances indicates that the defendant suffers from drug use from a young age, along with undiagnosed and untreated mental health issues of some kind. He felt abandoned by his biological parents, but had a devoted adoptive family who raised him in a supportive and loving environment. Defendant did not resist law enforcement when arrested and confessed fully to both murders. The court has further considered giving great weight to the advisory verdict of the jury, who recommended that the death penalty be imposed by a vote of 9-3 on count 1 for the murder of Kristine Melton and a vote of 10-2 on count 4 for the murder of Diane Ruiz. The court recognizes that there is no mathematical formula for considering the aggravating and mitigating factors. It is not enough to weigh the number of aggravators against the number of mitigators. The court carefully considered the nature and quality of each aggravator and mitigator. Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict. The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder. Accordingly, it is ordered and adjudged that the defendant, Wade Stephen Wilson, be sentenced as follows. Count 1, first-degree murder of Kristine Melton. The defendant is hereby sentenced to death. Count 2, grand theft of a motor vehicle. The defendant is sentenced to 5 years imprisonment in the Florida Department of Corrections. Count 3, battery. The defendant is hereby sentenced to 364 days in the Lee County Jail. Count 4, first-degree murder of Diane Ruiz. The defendant is hereby sentenced to death. Count 5, the burglary of a dwelling. The defendant is hereby sentenced to 15 years imprisonment in the Florida Department of Corrections. Count 6, petty theft. The defendant is hereby sentenced to 364 days in the Lee County Jail. The defendant is given credit for all time served on this case on all counts. All counts are to run concurrent with each other, meaning at the same time.
Dude, he was a foster kid, though, too. So his parents didn't even want him. Now the world doesn't want him. Holy shit. The defendant is committed to the custody of the Department of Corrections for execution of this sentence as provided by law. The defendant is hereby notified that these convictions and sentences are subject to automatic review by the Florida Supreme Court. If he cannot afford an attorney to represent him in any appeal, the court will appoint one for him. Are there any other matters to present to the court?
Briefly, Judge, the state would be seeking $17,500 cost of prosecution.
I'm sorry, how much?
$17,500, Judge.
All right. Any objection?
No, sir.
All right. that will be imposed then. Any other terms or conditions?
Absolutely, Judge. We just want to make sure that Mr. Wilson has absolutely no contact with the victim's family in this particular matter.
There'll be no contact ordered with any of the victim's family members and anything else. All right.
Judge, I understand he has other cases pending.
I sprayed her for the first time. She freaked out.
Wilson asked me to ask the court within whatever authority you have to get him to death row as soon as possible.
Okay. Well, in relation to those other cases, I know we have cases pending here in the circuit. Today is not the day to handle those. I would maybe put those, I could do it as early as September 16th. I believe that's Monday morning.
That's Malcolm's case, Judge.
Yes, Your Honor. Malcolm Dowling from Mr. Wade Wilson. September 16th would be fine, but
Okay. Well, I think it'd be more appropriate to handle that at a different time. So let's do that September 16th then at 9 a.m. for the other cases, which are case numbers.
20 CF 16591 and 23 CF 15499.
Okay. And we have court on 16th, right?
Yes, Your Honor.
Okay.
Judge, if I may, he also has a VOP warrant out of Broward County, Palm Beach County. I'm going to get in touch with the authorities over there, but if need be, we'll ask the court to ROR him on that VOP warrant so he can be taken up to.
Well, it's not a motion in front of me today, but if you certainly are able to file whatever you want to file, and
Yes, sir.
I'll consider it.
Thank you.
All right. Anything else?
Not from the state, Judge.
All right, sir. Then, Mr. Wilson, you will be fingerprinted and remanded to the sheriff's department. You'll be held without bond and for transport to the Department of Corrections when it's appropriate. If nothing else, then we're adjourned. And I'll give you your copies. The original. Mr. Shirley or Mr. Hollander? Well, one for the state, one for the defense. Thank you.
Thank you so much.
Does he do it out? What's going on? He has fingerprints? That was weird. What is going on? What the heck? They get his fingerprints in court for? Ever seen that? Was it because it's the death penalty thing? Is that like what? I don't get it. The cops like, I don't know why are they gonna do this? Did you see him? Like, why you give me fingerprints? The cops like, I don't know. It's like fingerprints, man. We never do fingerprints here. I don't know. That's Sheila. It's always Sheila's, dude. You know. All right. Well, I guess that's it for that stream, y'all. Thanks for hanging out. I'm leaving now. Bye. Hope you have a good one.